Hi, welcome. Today we will be discussing about the introduction to law, and we will be discussing law in its general sense, its legal sense and non-legal senses, as well as the characteristics of the law, the sources of the law. Okay, so without further delay, let us go. The term law means any rule of action or any system of conformity. It determines the activities of men as rational beings, as well as the movements or motions of all objects of creation, whether animate or inanimate. There are two divisions of law. Law may be divided into two general categories. The first is law in the strict legal sense and law in non legal sense. Law in strict legal sense means that the law is promulgated and enforced by the state. Example of this is state law. State law or statutes like Republic Act. Republic Act 7877 is talking about the anti-sexual harassment law, Republic Act 9262, or the anti-VAUSI law, or the violence against women and children. The non-legal sense means that law is not promulgated and enforced by the state. Example of these are divine law, natural law, moral law, and physical law. Let us now go to law in its non-legal sense. The first is divine law. So what is divine law? It is the law of religion and faith which concerns itself with the concept of sin and salvation. So what is the sanction? What is the punishment if you disobey divine law? The sanction of divine law lies in the assurance of certain rewards and punishments in the present life or in the life to come. Most, most religions have concept of the afterlife. And some of the things that we have done today while we are living will have an effect in our afterlife. So that is the divine law. Natural law, on the other hand, is the divine inspiration in man of the sense of justice, fairness, and righteousness, not by divine revelation or formal promulgation, but by the internal dictate of reason alone. What does it mean? It simply means that man has a natural tendency to understand what is right and wrong. The question is, what is the binding force of natural law? Natural law is ever present and binding on all people, everywhere, and all times. There is in every man a basic understanding of right and wrong based on the understanding of fundamental standard of good or evil. Simply means that we understand by nature what is good or what is evil. Compared to divine law as the law of religion and faith is made known to man by means of direct revelation, like the revelation of God to Moses at Mount Sinai by giving him the Ten Commandments. Natural law, on the other hand, is impressed in man as the core of his higher self at the very moment of his existence or being, and even perhaps before that. Natural law has been regarded as the reasonable basis of state law, which simply means that all the state law is based on natural law, the understanding of man of what is justice, what is truth, and what is good, as well as what is evil and destructive in nature. Then let's go to moral law. Moral law refers to the totality of the norms of good and right conduct, growing out of the collective sense of right and wrong in every community. So that's the reason why we have laws about morality. Is this moral? Is this immoral? What is the sanction of moral law? There is no definite legal sanction for violation of purely moral law. Violation would be met by spontaneous social reaction in the form of public displeasure, contempt, or indignation. Conformity or obedience to moral law, on the other hand, would mean public pleasure, approval, or even joy. We can see it right now in social media like Facebook. When you do something good, people will give their likes, approval, and heart emoticons. If you do what is evil or displeasing in the eyes of society, then you will reap displeasure, hatred, indignation. Let us go now to physical law. Physical law refers to the uniformities of actions and orders of sequence which are the physical phenomena we sense or feel in the operation or course of nature. This order or regularity is called law only by analogy. The more known ones are the law of gravity and chemical combination. For example, the law of gravity simply states what comes up must come down. That is because of the law of gravity. The law on chemical combination simply means that you can combine the elements. You can combine sodium with chlorine to produce sodium chloride, or what we call as salt. Sugar is a composition of carbon, hydrogen, and oxygen. So that is the physical law. So that those are the law of nature or physical phenomena. Let us now go to state law. State law is the law that is promulgated and enforced by the state through its Congress. It is also known as human positive law, civil law, or imperative law. As a rule of action, only state law is enforced by the state with the aid of its physical force. It can be understood in two concepts, namely general sense, which refer to the mass of obligatory rules established for the purpose of governing the relations of persons and society. Example is the use of the law in this sense are law of the land or rule of law. When the president says no one is exempted under the rule of law, then he is talking about law in the general sense. Now we go to the second, which is law in its specific sense, which has been defined as a rule of conduct, just, obligatory, promulgated by legitimate authority, and of common observance and benefit. What are the characteristics of law? There are four characteristics of law. Law in its specific sense has the following characteristics. Number one, it is a rule of conduct. It simply means that the law tells us what shall be done and what shall not be done. As a rule of human conduct, law takes cognizance or recognizes of external acts only. Internal thoughts are beyond its scope or application. It simply means what the law will adjudge as good or punish as bad are only external acts like rape, like slapping, like robbery, etc. Internal thoughts are beyond its scope of application. We cannot punish a person by his thoughts, only by his action. And that is law as a rule of conduct. The second characteristic of law is it is obligatory. Law is considered a positive command imposing a duty to obey and involving a sanction which forces obedience. It simply means that it is mandatory, it is obligatory. No one is exempted in obeying the law. The third, it is promulgated by legitimate authority. A law to be valid must be promulgated by legitimate authority. In our case or jurisdiction, we have Congress, which is made of the Senate and House of Representatives. The laws enacted by Congress takes the form of statutes, while those of local legislatives are called ordinances. Number four, it is of common observance and benefit. We need to observe or obey the law so that we can also be benefited by it. Law is intended by man to serve man. It regulates the relations of men to maintain peace and order. And so, law must be observed by all or obeyed by all for the benefit of all. For example, We have ordinances or law mandating right now the wearing of face shield and face mask. We have to observe this law so that we can be benefited by it by minimizing the effect of COVID-19. So we go now to sources of law. So what are the sources of law? The first is the Constitution. The Constitution is the highest law of the land. It is the organic law. It is the fundamental law which the powers of government are established, limited, and defined. It is referred to as the fundamental law of the land, the supreme law, the highest law of the land, to which all other laws must bow. Laws enacted that are contrary to the Constitution shall be considered as null and void. The second sources of law or source of law is legislation. It consists in the declaration of legal rules by competent authority, which in our case is the Congress of the Philippines. So as we have said, law enacted by Congress takes the form of statutes like Republic Acts, while local legislation like city councils, provincial councils, and barangays comes up with laws, but we call them as ordinances. Next is our administrative orders, executive orders, regulations, and rulings. They are those issued by the administrative officials under legislative authority. Administrative rules and regulations are intended to clarify or explain the law and carry into effect its general provisions. They are valid only when they are not contrary to the law or the Constitution. The next is judicial decisions or jurisprudence. It simply means the decisions of the courts, especially the Supreme Court, in applying or interpreting the laws or the Constitution, form part of the law of the land. The decision of the Superior Court on a point of law are binding on all subordinate courts in what is known as the doctrine of precedence or stare decisis. Then we have customs. Custom consists of those habits and practices which, through long and uninterrupted usage, have become acknowledged and approved by society as the binding rules of conduct. It has the force of law when recognized and enforced by the state. A custom must be proved as a fact according to the rules of evidence. Example are customs in the bukid. All the working men and women have part of the harvest according to the customs of the place. Other sources of law includes principles of justice and equity, decisions of foreign tribunals, opinions of text writers, and religion. Lastly, we have conclusive presumption of the knowledge of the law based on Article 3 of the Civil Code. It says there, ignorance of the law excuses no one from compliance therewith. Simply means that no one is excused and can be exempted for not knowing the law. Under this principle, the law is deemed written in the heart and mind of every person. He cannot claim ignorance and excuse himself from compliance therewith because the law is engraved in him as a moral being. I hope that you understood what we have discussed today and you have benefited from it, and I will see you on my next video.